May it please the Court, Rachel Pickering of the Appellate Defender Office on behalf of Gerardo Urista. If you could please reserve 2 minutes rebuttal time. I have to tell the Court this is my first time in front of the cameras, and I expected to say something witty, but everything I proposed to my office was shot down, so they're a pretty brutal crowd. This morning's argument is really focused on the first issue regarding the plea agreement between Mr. Urista and the state. There is a second issue regarding an Apprendi violation. I've sent 2609 letters on those regarding what we argue is an Apprendi violation on the district court's finding of the deadly weapon being used, triggers the offender registration, and then the third is an Ivory issue. So, the standard review in today's argument is a question of law, which is quite favorable to Mr. Urista, as this court is not bound by the district court's ruling. Just to give you a quick background, Mr. Urista was charged with 15 charges, and he pled as charged. So he didn't have much going for him except an agreement by the prosecutor to recommend concurrent sentencing. And at the plea hearing, Mr. Urista did plead to all 15. And at that plea hearing, the district court said that it usually follows plea agreements, and it said that twice. It says, unless there are times when facts become presented to me at time sentencing, I may reject those, but I do usually follow the plea agreement. So our argument basically is that the state breached the plea agreement by effectively arguing against the negotiated sentencing recommendation. So we argue these comments effectively undermined, even though the prosecutor said, I'm going to recommend concurrent, her statements actually were just simply lip service.
Lip service, the prosecutor said 3 or 4 times, isn't that right?
She
At the
said
outset,
twice.
I think the prosecutor said, we're recommending the plea agreement, then went through probably
Yes.
how you would characterize it, don't follow it, but we then went through some cautionary observations she had, and then said again, we're recommending the plea agreement, and I think at the conclusion also said it. I think there was 2 or 3 or 4 times.
I counted 2
Okay.
on page 4 and on page 11. Actually, no, 3. So I'd say 3 times.
Yeah.
However, 3 should not be the answer to the question of whether she undermined the recommendation, because I'd like to read to you how she peppered the hearing. And I'll start. And I try to do this in mundane voice so you can capture the full effect. I know a lot about Mr. Urista. He's a very dangerous young man. Unless he changes his way, 1 of 2 things is going to happen. He's going to kill somebody, and he's lucky he didn't do it this time, or somebody's going to kill him. Now, that's how she starts things. Now, she starts things because she has prosecuted cases against him as a juvenile. She's been working on his cases since he was 14. Then she says how he's very entrenched in the gang. She points out his tattoos that he's had for at least 2.5 to 3 years. Then she begins editorializing his juvenile correction experiences. And this was not the plea hearing. And I've cited in my supplemental brief, editorializing other facts can be considered urging consecutive versus concurrent. He's about 15, almost 15 years old, and one would think that would be enough, that would cure somebody of wrongdoing. No, he essentially tore up the Atchison Correctional Facility. She talks about that. He was then transferred to Topeka. Again, you would think that after having gone through this, he would have changed his ways. No. He did not reform himself, is basically what she's saying. He was, and this is quote, he's given the opportunity to rehabilitate himself while in the correctional facility, didn't take advantage of a whole lot of those opportunities. Then, I have a few more. And see why I answered your question. There's 3 recommendations, but there's at least 7 comments. This young man has absolutely no remorse, number 1. This young man has absolutely no compassion or any kind of sympathy or empathy. He has no feelings about his victims. He just continually does these very violent acts. More. And this young man could care less. He could care less the havoc that he wreaked on the community. Before telling the court to sentence him to 102 months, it says as a warning, Your Honor, he may be young in chronicle age and may even look young physically to you, but I assure you that this is a young man who's extremely street savvy and has absolutely no qualms about shooting somebody. He's a menace to this community. He's a danger to the community. So she's using youth as a way of saying don't be fooled by his youth. Later, the final roasting of Mr. Urista, she says, she talks about his family support. She said, yes, it's family support. They tried their best to do what's right for this young man, and essentially he spat on their faces. So, with that recommendation, one wonders what she would have said for consecutive sentencing. You're left with what factors would indicate that she's recommending concurrent sentencing. I've gone through the record. The Court of Appeals said age. I've shown you the youth was not actually used against him. I've gone through the record and show you how his family support was actually used against him. He's turned his back on the family. And so we argue this is akin to basically undermining the plea agreement.
Did the court utilize what she stated in imposing? I mean, did the court actually cite to the state's position and what was articulated at sentencing for the basis or even a reason for imposing consecutive sentences?
I think I didn't hear that when he imposed consecutive sentences.
Right. I didn't see it either.
He did not. The defense counsel objects at one point, saying, don't even listen to what she said after she said recommend sentencing. And the district court said, well, I've heard this at the plea hearing. And our argument to that is there was much more given here at the plea hearing than simply at the plea hearing. You didn't hear about his juvenile past. We weren't discussed how her personal assurances that he would shoot somebody, that he's a danger to the community, that he has no compassion, no empathy, not to be fooled by his age.
Isn't your argument that the prosecutor went beyond facts? You know, we have some cases that have allowed the prosecutor to give bad facts or facts that would not particularly support the plea agreement. But isn't your argument that the prosecutor was giving opinion here?
Yes, and that's in my supplemental brief. I cited a case about editorializing the facts.
And the sentence that was being recommended was the mid-range grid box sentence.
Correct. Correct.
We've had some cases that said the prosecutor is permitted to argue why the recommended sentence should be given rather than some lesser sentence. And so the only lesser sentence here would have been the mitigated number in the grid box, correct?
Correct.
And so instead of 102, it would have been something like 99 or 199 or something to that effect.
Sure, that would make sense. But if they're going to do that, they need to make it clear on the record to the judge. Your Honor, I like to follow the plea agreement. I've given you some background. However, I like to, for your consideration about mitigating, and also parties can contract to that in the plea agreement, that they could argue. And what's important here is Mr. Urista was never arguing for a downward departure. She was not responding to the defense counsel trying to mitigate his bad behavior. And that's how this case is different. I wanted to jump to the error. There's some talk about, do we apply harmless error here? Do we just say it's a violation? Santabello, the United States Supreme Court case, basically reversed and remanded to the district court. They did not go through a harmless error analysis. If we do have to go through a harmless error analysis, the one I've discussed was, could this court conclude beyond a reasonable doubt that Mr. Urista would not have pled but for the state's agreement to recommend? And here he agreed to plead as charged, and the only thing he had going for him was the recommendation.
So that I understand you're suggesting that Santabello stands for the proposition that the error cannot be harmless.
Correct.
If I recall, the court there said remanded to decide one of two things, either whether to resentence as recommended or to allow a plea withdrawal. Isn't that what the court said the options were?
I believe so. I'm skimming it, and that's what I believe is what they came up with. We're not pushing for a plea withdrawal. That was never argued, just to plea as charged. And 102 months is a lot. That's over 8 years. So, if this court has no further questions, I could jump to issue 2 if it's interested. The Apprendi violation that we argue.
How do you argue that Smith v. Doe isn't dispositive of this issue? I realize it's an ex post facto scenario, but how do you argue around that?
I argue around it because Smith v. Doe was 2003, and that was then, this is now kind of argument. Smith v. Doe, the punishment for not doing the offender registration was a misdemeanor. Here, we now have a severity level 6. If you don't register 30 days later, it becomes a severity level 5. If you don't register within 180 days, you get a severity level 3. These are all person felonies. That's how I would get around.
So if I understand you, you're saying that registration is additional punishment because it exposes the defendant to these additional felony charges if there's non-compliance?
Well, we're saying it's punishment on a lot of different ways. Just the burden that a defendant must go through now. Every 4 times a year he has to register. He has to register in every county. Let me give you just a quick scenario. I have a client who lives in Jackson County. He goes to college at Johnson Community College, and he works at the Legends. That's 3 counties, Wyandotte, Jackson, and Johnson. He has to register in all 3 counties every 4 times a year. $20 a pop. He's losing I apologize for saying losing $240 a year on that. So we argue he has to jump through a lot of hoops now to register. Also, the significance of that he has basically limited freedom in movement. When Myers was decided, the defendant had 15 days to move. Now, under Cora, you basically have to alert within 3, I believe. 3 days. The timeline for which to alert the authorities is shrinking, and that limits one's movement. And so we would argue that's how they're creating a higher hurdle. And what's interesting is in Myers, it took a look at, well, whether it was punishment or not, does this new registration increase the penalty, and that certainly does that. These offenders now have at least 10 years that they have to register. And what's also interesting is in Myers, the defendants were able to seek a discharge to be relieved, and now under Cora, they are not allowed that ability to say, I've been a good guy for the last 8 years, I've been not getting any trouble, and I like to be removed from that.
But the whole notion of Smith v. Doe was that any kind of harsh consequence as a result of not registering or violating the registration requirements is not additional punishment to the underlying crime. That's the kind of the theory as to why they say it's not punishment.
Right, and I guess my answer, and to answer it better this time, is the question of that was then, this is now, is they went through different ways in which it could be considered punishment. They said, well, you have to do it on the internet. This is 2003, but our argument is the internet is so pervasive nowadays that that factor needs to be relooked at. It also, Smith v. Doe mentioned that, there's a criminal liability if you don't register. Yes, that was a misdemeanor. Now you're looking at a possible person 3 felony. Also, Smith v. Doe, although you said it's ex post facto, is looking at whether it's a civil proceeding, and we don't have that analysis. So that's why my answer is that was then, this is now, of a question of, well, within 10 years, what has happened? And the legislature has definitely increased all the number of people who have to register and all the hoops one has to jump through to register. I see I'm out of time. If I ask this court to reverse and remand for resentencing.
Are there any questions? Thank you.
Thank you.
Good morning. May it please the court. The state appears by Assistant District Attorney Jody Litvin. I'd like to start with the first issue about the plea agreement, and it's the state's position that the plea agreement in this case was not violated and that the prosecutor's comments did not rise to the level of undermining the recommended sentence in this case, which was to run all of the sentences concurrent.
Do you think of anything the prosecutor could have said to encourage that would have met the standard for undermining? Anything more that could have been said that would meet the standard for undermining the plea agreement?
I think she could have said that concurrent sentences, could have just flat said concurrent sentences aren't appropriate in this case.
Right.
And gone
that would be
against,
an obvious violation.
Yes.
But is there anything else that could have been said that was not said that could imply that that was the outcome desired?
You know, I'm sure there are other things that could have been said about elaborating more on the facts. There were 15 charges here, so I'm sure she could have gone into detail about all of the facts and all of the charges. I'm sure she could have detailed his juvenile history even more, since he did have quite a lengthy history. And I think that she could have also not made the recommendation 3 times and not made it at the beginning, in the middle, and the end, essentially.
What was the point of any of these comments, other than to try to influence the judge in the sentencing in a way different than the plea agreement?
Well, I think that the prosecutor had a duty to provide any information that the court would have found necessary to make his sentencing determination. And although these comments were perhaps unnecessary or maybe even excessive, she was simply providing that information to the court so he was able, so the sentencing judge was able to make his determination about what a proper sentence would be. And I think a lot of it came from also the...
What determination? What determination did the judge have to make if you're recommending a sentence and say, we've agreed and we're recommending this sentence, so why are you providing information for a decision that you're asking be made concurrent?
Well, the judge can still go against the plea agreement, of course.
Can go against,
sure.
But why are you providing information for the judge to disavow or to reject your recommendation?
I don't think it was made to reject the recommendation. I think also, if I can maybe address it in this way, it was a 102-month sentence, I believe, was the middle box, and to run them all concurrent. That's still a very lengthy sentence, and I think it was addressed in my appellant's argument that it was pointed out that the prosecutor can still make comments regarding how that higher sentence is appropriate, because the judge could have gone with the even lower sentence.
Is it okay for her to speculate? How could it possibly be okay for her to speculate, he's going to kill somebody? He's lucky he didn't kill somebody this time. That's not based on a fact. That's her total speculation. What could possibly make that statement appropriate?
I don't know if she was referring to, in some of the victim impact statements, where they said it was a dangerous crime, and maybe attempting to advocate on their behalf, and by placing that statement in when talking about the facts.
It wasn't appropriate.
And I'll agree that they were excessive, but I don't think that it rises to the level of undermining the complete recommendation to run them concurrent.
What do you think is your best appellate case that says you're right, that this was not undermining the sentencing?
Well, I think there was, I don't know if Hill and Johnson were.
The Court of Appeals first referenced Johnson, and I've read it, and let me take that one off the table for you.
No, Johnson.
Okay.
Okay.
So what's your best case?
I think the other one would have to be Hill, as the Court of Appeals also noted too. And if I can get to that case. I'm sorry. In Hill, the state also noted to recommend the controlling term of 2 consecutive life sentences in Hill, and there the state never even made the recommendation. I think that was the case where the prosecutor just referred to the PSI, never explicitly told the court what they were recommending, and sort of sidestepped it altogether, and then just went into her comments, or their comments. And so I think in the fact that no recommendation was explicitly made as to following the plea agreement.
But in Hill, there wasn't this level of editorializing, and I think that's not a bad way to look at this. I mean, it really is. It's not just relating, oh, these are the facts of the case. This is almost testifying about the character of the defendant. And so I do think it's editorializing, and none of the cases that are in your brief or in the Court of Appeals decision seem to go to that extreme. So I'm just trying to figure out, is there anything out there else that I should look at?
I would just have to submit with the cases that were on the brief and cited by the Court of Appeals at this time. I would like to note, though, that I think it is significant that the trial court did address when there was an objection by defense counsel made, which was definitely a questionable objection, I would call it, because the court recognized that the prosecutor was making these comments and basically dismissed all the comments that she made about the juvenile history and stated that these comments were very similar to what was given at the factual basis at the plea hearing. So I think it's...
But as appellant's counsel points out, that's not true. A lot of these comments were not made at the plea hearing. They were, especially the opinion-related comments.
Well, and I think it was his statement, though, or the district court statement, that he was not going to take into consideration the other comments besides the factual basis surrounding the crimes and what he had already read in the victim impact statements.
And my problem with that is if we draw the line there, then that says that the state can cut a plea deal and then go say anything it wants. And it's sort of always going to be harmless because we all know that judges are neutral and not going to take... I mean, somewhere in here there has to be the integrity of the contract and the state's willingness to uphold its part of the deal. And that's why I think we can't draw the line just that the judge is going to cover it. Seems like it has to be something else. And that's what I'm struggling with, frankly.
Okay. I mean, I don't know if if that can be said in every case as far as the judge flat out telling the defendant and the prosecutor that he's not going to take those comments into consideration. So I think it is valuable that in this case he said that.
That's a harmless argument.
Yeah. Yes.
So are you arguing both that they were not improper statements and that even if we find they were improper, they were harmless?
Yes. And I don't know if the state's brief properly addressed the harmless error argument. I don't know that it's been squarely addressed what exactly the harmless argument error should be for a breach of a plea agreement.
Do you have an answer to opposing counsel's observation that the U.S. Supreme Court in Santabello didn't speak to harmlessness when there's a breach of a plea agreement?
I thought in that case that they did speak to harmlessness. Maybe I'm thinking of another case.
Well, how could it be harmless when the only consideration given in this contract or in this understanding was that they agree with a 102-month concurrent sentence, and then you breach that aspect of the agreement? That's the only consideration that was given. How could it possibly be harmless?
Well, and I think maybe the way that it should be addressed is that it could be harmless if the way in which we breached it, which would be to the comments that the prosecutor made, had no effect on the sentencing judge's determination to go against the plea agreement, if that makes sense. So, and he said here, clearly he didn't take at least he didn't take the juvenile history and the comments about the prior juvenile history into account here. So I think that if we look at it from, did it change the sentencing court's determination of what the defendant's sentence should be, then it could be harmless. It could be structural error. And if it did not, if the breach did not change the sentencing court's determination, then it could be harmless error.
And would there be any way to apply that test unless the sentencing court fessed up and said, oh golly, I didn't know all that stuff, thanks for telling me you're going to jail for a whole lot longer than I was going to send you when I walked in here this morning?
I think that there would have to be some sort of finding made or statements made by the district court as to why they were not following the plea agreement. And if those comments had an impact on not following the plea agreement, then that would be what you could use to say it was.
But how likely is that when the trial court has no obligation to make findings to impose consecutive sentences?
Unlikely, probably, but I think it could still be. I think it could still be an option. I think it could still be an option. If there are no other questions on that, I can move to the Apprendi issue.
Good. Moving to the registration, why isn't the fact that a defendant has to spend at least $80 a year in registration fees an additional penalty for imposing registration? So I mean, it's not only the risk of another felony, but it's an actual, real, out-of-the-pocket imposition that's additional for those with registration as opposed to those that don't have to register.
I think that the extra fine, I think the Court of Appeals has addressed that this is not a punishment, but a way to, I can't think of the word, to pay back, or a way to assist with the registration requirements. It's not a fine per se, but it's a way for the defendants who have to register.
Well, you could call it an administrative fee if you want to, but what I'm saying is if you sentence someone to registration and you sentence the other person that doesn't have to register, the existence of the administration fee, why doesn't that create an additional penalty?
Well, it also goes to, it's not increasing the maximum penalty for the crime in which they were originally convicted. So I guess if we look at Apprendi and it's not going above the statutory maximum, I think that that's what is at the heart of that rule.
You're saying that's limited to time, that you can't consider the extra money?
I'd say that's a fair interpretation of what I'm trying to say.
Apprendi only applies to prison terms. It doesn't apply to monetary consequences.
That would be the argument, that having to register would not be the penalty, or the fines included in having to register would not be considered an extra penalty. And we would just ask that you would follow the Court of Appeals decision in this case and determine that the plea agreement was not breached and that there was no Apprendi violation in this case.
We have any questions of counsel? Any further presentation?
No, Your Honor.
Thank you, counsel.
Thank you.
I like to waive rebuttal.
Any objection to that? All right, thank you, counsel. Thank you both for your arguments this morning. The court will take this matter under advisement.